New segment monthly here on Afternoons Live is Law Talk. Ringstrom, DeKrey, your criminal defense attorneys. You've heard them here before. They said, you know what, let's do this all over again. In fact, it's an opportunity for you as listeners to join in. You got questions about what your rights are, you get pulled over, now what? Or, of course, if you have a friend that's done something that you want some legal advice or some questions answered, now's the time to do that at 35270. In studio, Bruce Ringstrom. Bruce, welcome back, man. How you been?
Good afternoon. Good to see you, Tyler.
Good to see you. Dane DeKrey also. Always a pleasure, my friend. Welcome back to Afternoons Live.
Great to see you.
Law Talk is here. First, I want, for those that might not have had the last time that you guys were on, explain where you are, what the criminal defense, your approach to everything. Bruce, I'll send that your way.
Sure. So my name is actually Bruce Ringstrom Jr. My father is Bruce Ringstrom Sr. He is a criminal defense attorney, and he works with us at Ringstrom DeKrey. We are a criminal defense-focused firm. That's 98% of what we do. The remainder is civil rights, what's called 1983 work, where we sue police officers and the government for mistreatment of civilians. And at this point, we pretty much only do big, serious cases, federal drug cases, assault, murder, bank fraud, things like that.
Very good. Dane, anything you want to add?
We joined together 2 years ago.
Yeah.
We both used to be public defenders. I was on the federal side. Bruce was on the state side. We both knew of each other and had seen each other in court and around town. And he was the person that I wanted to practice law with, and we were able to do it. And now it's been about 2.5 years, and the future is bright.
I would say in addition to what you guys do when it comes to criminal defense, one thing, you've been a great resource for us too. Here on Afternoons Live, when there's been questions about things going on in the news, saying, explain this to me, you've always been very open and with your time to come on and do that. And I know that the listening audience has appreciated that. Whether that's our conversations about the Cassandra Black Elk situation that I know, Dane, you were involved with, or some of the other things that I want to dive into today, because I've seen a lot of news about situations in North Dakota, Minnesota that seem quite similar, but the outcomes have been quite different. When it comes to police shootings, you were talking about what the defense side of this is. And we followed along almost in real time in North Dakota, the Shane Netterville situation, in which you had an officer-involved shooting. There was questions. Body cam footage was released. The Attorney General in North Dakota comes out and says, no charges brought. And it wasn't that long ago in Minnesota, you got Ricky Cobb in the situation there, and I think it was, last week, 2 weeks ago, in which the police officer was charged. The handling of this is so different, but I don't know why. As just somebody that casually follows along with this sort of stuff. So, Dan, I don't know if you or Bruce, what's the difference or what's the standard when it comes to officer-involved shootings in which a civilian is found deceased because of it, and then you have such drastically different outcomes here?
Yeah, so the important first question to ask yourself is, are we talking about criminal liability or civil liability? And the difference is, when an officer shoots someone and kills them, criminal liability means, are they going to have to go to jail for what they did? Civil liability is, are they going to have to pay the dead person's family money for what they did? And what you're talking about, at least at the beginning, is the criminal side.
Okay.
And in North Dakota, in the Netterville case, there wasn't criminal charges. And in the Cobb case in Minnesota, criminal charges were filed. And that is really, I think, what lots of people are asking, which is, what is the difference between the two? Why was one charged and why one wasn't? And the best person to answer that is probably Bruce in this situation.
Well, Bruce is conveniently sitting right next to you. Bruce, I'm curious what your answer is then.
Well, in the United States, there's about 1,000 people killed every year by on-duty law enforcement officers, according to the Washington Post. And of those, something on the order of 10 to 20 officers are charged with murder or manslaughter every year. And a small proportion of those are actually convicted, probably a third of those, so 6 or 7. So you got two differences here. One, there are factual differences, right? The shootings were different. The vehicles were different. The behavior of the individuals in the vehicles were different. So those are factual differences. There are also statutory differences. The law in North Dakota is actually a little bit more in favor of the use of lethal force or deadly force than it is in Minnesota. Minnesota, since the George Floyd murder, has changed the use of force laws, where law enforcement has to articulate with specificity. They have to say exactly why. They have to be able to. Why did I use lethal force? That's a much higher bar. And so those are some of the reasons why we see differences here.
This is pretty maybe speculation, more opinion on this point. Then, because you mentioned George Floyd, I figured we'd get to that point. And I know everyone's got their opinions on that day, and of course they've all shifted because of things we're not going to dive into here. But because of those law changes, let's say that didn't happen, and the Ricky Cobb situation happened. Do you think it would have had the same outcome, or is it primarily due to the law changes following George Floyd?
You know, it's an interesting question that I think calls for a little bit of speculation. I will say that there is a stark difference in the approach to criminal justice from the North Dakota Attorney General Drew Wrigley and the Hennepin County Attorney Mary Moriarty. I know Mary quite well. She was a long-term public defender. She's very smart, very skilled trial lawyer. She takes a different view of criminal justice. So even without the change in the law, might she have seen these facts and decided we're going to bring charges? I think it's quite possible.
Okay. Ringstrom, DeKrey, and Law, their criminal defense attorneys are in studio. I've gotten a lot of messages already coming in for you guys. Questions at 35270. Do you want to dive into those, or do you want to talk about the question that I had for you when it comes to what's going on in Michigan? Because that is one of the questions here. Let's start there, and we'll come back with some of the questions. In the Michigan case is still so fresh. For those that are just joining us, a mother was charged with manslaughter because her 15-year-old son at the time did a mass shooting at a school, killed 4 classmates. There's been 4 now sentences brought to her, will be separate sentences, but this precedent being what it is, I'm just curious from a criminal defense side of this, your response. I mean, is this a precedent? Is this something that's going to now spread to other states?
Yeah, I'll take that one.
Okay.
It's definitely a precedent. As far as I know, it's the first time in the country that someone has been found criminally liable for the actions of their child who commits a school shooting. And as a parent of 4 children, I can see why we as a society want to disincentivize school shootings in a new way, because we haven't done a good job to date. But as a criminal defense lawyer, I worry that this exception may become the rule. And by that, I mean creative prosecutors may begin to think this is the way to charge every single case. By definition, if your son or daughter commits a school shooting, and usually it's your son, you should be held liable. You're going to have to face criminal charges. I worry about that. In this case, the facts were relatively egregious. And so it's easier for me to accept that result, knowing that hopefully they are cabined or only related to this woman's conduct. Because I worry that if this is overused, it will become misused.
Mm-hmm. The questions that I got, or comments, I guess, earlier when we were having this conversation with listeners, is slippery slope mentality. Okay, let's say you're having a house party. I mean, it's not like it's been uncommon to find out that all of a sudden mom or dad's supplying the alcohol. All of a sudden, the son or daughter gets hold of the car keys. They're intoxicated. They go get in a car accident, and somebody winds up dead in that other vehicle. Would this be applied to that as well as far as manslaughter? Bruce, I'll ask you that question. Or is this totally, entirely a separate situation?
Well, you're asking whether there's an analogy, whether
Sure.
the move in the way that they're prosecuting in these school shooting cases might be applied to a different situation, as you say, a criminal vehicular homicide. Somebody drinks, drives, kills someone, they're underage, mom or dad provided the alcohol. It's not beyond the realm of possibility. It becomes a factual question. You know, the facts would matter. Did the parents actually furnish or not furnish the alcohol? In the shooting, did the parents have the firearms locked up? Did they have a reason to know that the child was mentally ill? Those are things that you put in front of a jury rather than, deciding before the trial.
Very good. Guys, let's take a quick break here. It's Law Talk on Afternoons Live. You got a lot of messages into 35270. We're going to get your answers provided when we come back right here on KFGO. Law Talk here on Afternoons Live. Dane DeKrey, Bruce Ringstrom Jr. here taking all your questions at 35270. You did something wrong, or your friend conveniently did something wrong? Got questions? They got answers. You're going to be shocked, fellas, that it's a lot of DUI questions in. Tyler asked the question, what's the difference between a DUI and actual physical control?
Well, I can take that. I will say that in the months to come, we will do a DUI-specific show. We will answer all of the main questions that come up over and over again. Actual physical control simply means that you're in the vehicle. You have a blood alcohol content, typically 0.08 or above. You have the capacity to operate the motor vehicle. So let's say you leave the bar, you believe you are too drunk to drive. You get into the back seat of your car and you try to sleep it off. That's actual physical control. Don't do that.
I have heard anecdotally from a friend. Serious, though, from a friend.
With the initials are TA.
Yeah,
right?
no, it's certainly not. I need to make that abundantly clear for everyone else listening. I did a lot of dumb things when I was young, but not like this. Okay, so somebody goes in to sleep it off. Throwing the keys under the vehicle. So that way your keys are not physically on you, so I couldn't possibly turn the car on. Any merits to that?
There is a little bit of merit to that. You are also inviting, of course, someone stealing the keys or them getting lost. But if you don't have the capacity to turn on the vehicle, you don't have actual physical control. The problem is, I think, depending on where they are, the case may still get charged out and may still go to trial, and the prosecutor may argue that you hastily threw them just before the police officer arrived.
So for that, Fred, don't do that. But here's, and I know this may be jumping over what your guys' advice and answers are, because I think that individual that would have done that, you think that they're well-intended, right? They know they should not be driving. They might not have a place to stay, so you're going to sleep it off in the vehicle. So the intent to do good is there, but of course, by the eyes of the law, that doesn't matter.
In 2024, it is about a $30 expense to buy a little blood alcohol content tester. Keep it in your trunk or in the lockbox of your pickup truck. If you blow more than a 0.04, take an Uber or wait.
Very good. Sound advice. Dane, anything to add?
I bought one on Bruce's sound advice, and I think it's a wonderful decision, and it takes the guesswork out of it, and it keeps you mature and safe on the road.
Very good. Prevention, boys and girls. 35270 is provided by Adventure RV. Tyler asked Bruce if a drunk driver stopped in Minnesota should refuse to take a breath, blood, or urine test. Well, they get charged with refusal to lose their license for a long time.
Well, the way the refusal statute works in both Minnesota and North Dakota, there are some variations, but the act of refusing tends to result in consequences that are just as severe as if you took the test. Now, there would be a very rare situation where you get an opportunity to contact an attorney, and if the attorney tells you to not take the test, the problem is no attorney who values his or her license is going to do that because that lawyer is telling you to break the law. In that situation, when the officer tells you refusal to take a test is a crime, that is true. Your job in that moment to take as much time as you are reasonably allowed before you take the test in hopes that your blood alcohol content drops beneath the threshold.
And to add to that, what often officers won't tell you is that you can either have your blood tested or your breath. And blood takes longer because an officer is not going to draw your blood on the side of the road. And so if you think that you're going to be very close, right on the line, you may well want to ask for the blood test instead of the breath test, because the breath test is right there, portable on the side of the road, pretty much immediate. The blood test is probably 20 to 30 minutes before you're going to get that, and hopefully the alcohol is dissipated enough that you're just underneath.
And it gets to be a real tangled mess, Tyler, because there's actually two blood or breath tests that they give you. One on the side of the road, and then one at the cop shop with the big machine. And that's typically where you have an opportunity to demand a blood test. We'll talk about all this in the months to come.
Very good. And I'm sure these questions will appear every time in between then and now as well. 35270 is the way of which you choose to get a hold of us here on Afternoons Live. It's Law Talk. This Wednesday of the month. It's going to be this Wednesday every first Wednesday of the month. What we got coming up, KFGO News at the bottom of the hour, we'll check in with Paul Jurgens. More questions coming in. And what I'm going to have you guys do, so keep this in mind here, because you're criminal defense attorneys. I'm getting a lot of questions from people that are directed towards attorneys, but maybe not criminal defense. So I want you to explain the realm of which you guys practice when we come back so we can clarify for some of the listeners out there. Dane DeKrey, With us, we got Bruce Ringstrom Jr. with us. I'm Tyler Axis, Law Talk right here on KFGO. Well, you just heard the promo for Law Talk. Gets underway right now. Ringstrom DeKrey, criminal defense. And before I get into this, we had asked you guys about the Michigan mother, that ruling, and then I look up over one of your shoulders in the monitors, basically now echoing other attorneys across the nation exactly what, Bruce, you had said, that this being one of those things that now prosecutors might be looking at. That
you heard it here first.
Yeah, right here on KFGO. Don't have to be watching any national news outlets. You just keep it locked in to 790 AM or 104.7 FM KFGO. Before KFGO News, I said I want you guys to answer this question because I got questions coming in for, yes, attorneys, but your criminal defense attorneys. People hear that and they're like, well, what does that mean? What do I ask these guys that I wouldn't ask, say, somebody when it comes to a will, for example?
Sure. We are criminal defense attorneys and civil rights lawyers. We do not have a general practice. Don't come to us with a will or an adoption. We don't do that kind of work. So what does that mean? We represent people charged with crimes in state court in Minnesota and in North Dakota. We represent people charged with federal crimes in the District of Minnesota and the District of North Dakota, and we reserve the right to go to other districts as well. We also represent people, and this is very important because we're kind of rare in this way, we represent people under investigation or in what's called a pre-charge state. Sometimes people get the feeling because they were approached by a detective that something is amiss. Those people quite often need an attorney even more than someone charged, because if you can shut it down before the charges come, an ounce of prevention is worth a pound of cure. And then we also do what's called 1983 civil rights cases. I'm going to let Dane talk about that, but essentially it's about suing police officers.
Okay, and then the question, why would somebody be needing to have that option, Dane DeKrey?
Because that option is woefully underserved or non-existent in my experience in North Dakota. There just aren't a lot of lawyers or law firms who are suing police officers in the narrow circumstances in which they should be sued. And I want to say that, narrow circumstances. There's a hot button component to that, which is, you support the police. Why'd you do that? And I actually think having a robust civil rights practice supports the police more, because it weeds out the bad apples. And if the officer has done nothing wrong, we will never sue, nor if we did, would we win. And so it's the accountability in the system that we are trying to bring to North Dakota.
I'm glad you got to that point, because that's a common thing that I get all the time. When we're talking about those heavy topics that involve law enforcement and, an act of force was used, people say, oh, yeah, they're just going to sue. That's what Democrats do. That's what liberals do. And that's why when we talk about the difference in Minnesota, North Dakota, where there was an officer-involved shooting, the outcomes, of course, based on law different, but also just the mentality of what went into those laws being made. So, backing up that, look, this is accountability, and those that do no wrong need not worry.
Completely. Whenever I'm pushed back in that regard, I say, if law enforcement has dotted every I and crossed every T, I will be able to do nothing to them on the civil side. And we are very selective in our cases as well. Many people call us with perceived wrongs by the police. From my time at the ACLU, I got a lot of those calls. I still do. But what I tell them is we are going to kick the tires very carefully on this. In the vast majority, we come to an internal conclusion that we do not think there should be liability, meaning the officer should not have to worry. The few times that we do, we file lawsuits because we are confident that that needs to be held accountable, rooted out, and so that law enforcement going forward doesn't do that again.
So the way I understand this, and Dane or Bruce, either one of you can take a crack at it, that the threshold to say, yep, we will take your case when it comes to, as you guys have done the 1983, what civil rights suing law enforcement for any wrongs, that threshold seems higher than just, hey, I feel like I need some defense because I got pulled over and I all of a sudden was intoxicated.
Yeah. If you are generally mistreated or disrespected by law enforcement, that is unfortunate. And I mean that. People should be treated with respect. But the bar is very high. And there's a term in law called qualified immunity. Law enforcement gets a lot of latitude because they do a dangerous, complex job. And so the behavior really has to be outside of bounds for competent civil rights lawyers to bring a lawsuit.
And what Bruce is talking about is the legal barriers. I was talking about our own internal law firm's
Right.
barriers. But even if we decide to file suit, there is still qualified immunity that makes it even difficult for us to win when we think the law has been violated, because the law, rightfully so, gives officers a lot of leeway in their duties, in the execution of their duties.
One thing that I've seen more as we progress into the 2020s here is laws requiring body cams be worn. Yeah, because I think about you have law enforcement with the qualified immunity, as we've all agreed that warranted. I mean, the job they do is very, very dangerous. But then it comes down to, as somebody who's perhaps done some criminal activity, I mean, you have the kind of he said, she said type mentality. So how do you bring any evidence that, that officer did, in fact, cross the line? I got to assume that body cam footage is probably the biggest piece of evidence, or am I wrong on that, Bruce?
Well, it's a very important piece of evidence, and it's changed dramatically in the 15 years that I've been practicing criminal defense. In 2008, 2009, you had squad videos for DUIs, which very often were VHS tapes. And it was new to have a digital server. Now, all of these not all, but the vast majority have body cams on their chests. And so you have you could have up to a terabyte of video to watch in a case. The real question is, what parts of those body cams do we get to see? Because sometimes when there is an officer-involved shooting or some other law enforcement-related incident, the public only sees part of it. Now, if I'm representing someone, I should be able to see all of it, but the selective publishing of that video can change perceptions and make people think one thing happened when, in fact, something else did.
You got a question? Oh, go ahead, Dane.
Well, I think that's been one of the concerns when I've read about in both the Netterville and the Cobb case, is that the police get to hold that body cam footage and they get to release it in the way they want. And what's difficult about that is if you can't see everything, you are left with a trust but unable to verify situation. And so when the police say, look, the body cam footage is very clear in both Netterville and Cobb, the response is what you've showed us. And so what Bruce is talking about, and what we talk about a lot, is when we are representing someone on a criminal case, like if we had the Cobb case, we would be able to see all of it, and that would help shape our defense in the case. In the court of public opinion, you don't get that as much, and therefore there are oftentimes unresolved issues that people it's an itch that they can't scratch.
You guys have questions, they got answers. Gals 2-352-70 is how you can get a hold of us at the Adventure RV Text Club. People are wondering if this will be podcast. Yes, the full conversation will be podcast at After News Live's KFGO page. Actually, wherever you get your podcasts, just click subscribe and you won't miss Law Talk. We're doing this every month, first Wednesday of the month. Question, I guess, that pops up in my mind when it comes to that situation. Do you get often that, you guys are just all trying to, ambulance chasers type thing, you're anti-law enforcement? Do you guys get that, and how do you push back? I mean, I think you've done a stellar job of, look, the bar is set high for good reasons, but I'm just, as a defense attorney, how do you combat that?
There's, of course, we're talking about two different ways of practicing law. Defending people charged with crimes, where we cross-examine police officers in court to attack the evidence they're trying to put forth, and occasionally suing police officers for their bad actions. About 40 years ago, my father, Bruce Ringstrom Sr., was approached by a police officer in the courthouse, and he said, Ringstrom, I don't like you very much, but when I'm out on the street about to arrest someone, I'm thinking, what are you going to do with the case? And that really made Bruce Sr. feel good, because it told him he was having a positive effect on law enforcement doing things the right way when they were out in the field. We are part of the immune system of the criminal justice system.
That's brilliantly said. When you think about it that way, of if it's in the back of the mind, making sure I'm doing everything right, then that's a threshold that they've now made sure that they've got to live up to, and that you as an individual that's now maybe getting those tight cuffs around you, well, at least they're doing it by the letter of the law. Dane?
and you earn their respect through your diligent, honest work. I think for both Bruce Jr. and I, over time, there might be times where police officers or law enforcement say, I don't like the way that cross-examination went. I don't like the lawsuit you filed, but you are honest about it. You aren't underhanded. And I get called an ankle biter. And at first I didn't like that because I thought I was younger, a young attorney, but I've taken it as a point of pride like Bruce Sr., which means I'm going to always be checking to make sure you're checking the boxes. And if you are, you'll be just fine. But if you're not, we'll find it.
You know, Tyler, I realized that I was doing the right thing the first time a police officer came to me and said, I want you to represent my son.
Mm-hmm.
Wow.
Mm-hmm.
That says a lot right there, doesn't it? Bruce Ringstrom Jr., Dane and DeKrey. It's Law Talk. We'll come back. Final segment. We still got time for your questions. I got a lot of comments coming in, which I'll relay back to these guys as well. I'm Tyler Axedis. Law Talk wraps up next year on Afternoons Live. Law Talk right here on Afternoons Live, first Wednesday of the month. Get that on your calendar, and then if you got questions between then and now, well, write it down and send it in at 35270. Bruce, I'm going to throw this one your way. Ringstrom DeKrey, the defense attorneys, Bruce Ringstrom Jr., Dane DeKrey, our guests. There's a question about, hey, is there, I don't know if I want to call them frequent flyers. Do you get contacted by people that say, look, the police are just out to get me, man?
Yes, I do. What happens is if you've had contact with law enforcement a couple of times, there's both the official reports that get generated, but within law enforcement systems, they make margin notes. You know, if this person is a known drug user or known to be combative with law enforcement, you know, those kinds of things. And so then if law enforcement sees you and you roll a stop sign that normally the cop would just look the other way, you might get more attention. So those are things, for better or worse, that definitely happen.
So, warranted is somewhat, I guess, my takeaway from that. That, okay, yes, they might feel like they're out to get you, but, well, what have you done maybe to get that extra attention? Am I reading that wrong?
Well, the problem is, what if I was a young person who made a fair number of mistakes, I get myself cleaned up and I'm rolling straight, and I still get pulled over all the time? Because the cops have an institutional memory. There's a computer memory of that kind of behavior. And so I'm getting pulled over. I'm late for work because of something that I used to do 6 or 7 years ago. That's a problem too.
Is there a way to get that clean? I mean, I clean my record up. I mean, does that come after we talk about statute of limitations? Once it's on your record, it's on your record?
I mean, it's sort of like reputation, right?
Yeah, right.
If you burned someone 20 years ago and they're still alive, they remember you burned them 20 years ago.
Well, keep that in mind, ladies and gentlemen. Dane, anything you want to add to that? I mean, we're talking about law enforcement. We're talking about those individual rights. And, I don't think anyone's seeing like, okay, that's not shocking that, yes, they keep information on you if they've encountered you, but what am I missing in this? Anything?
I think it's important to say the quiet part out loud, that this is not meant to say this is by the Fargo police specifically, but empirical research says that police officers tend to encounter people of minority races more than people of white skin. I can't tell you off the top of my head our calls into our office about those civil rights cases, but I'm thinking right now of the current cases we have, and the majority are people who are minority, whether that's Native American, Black or brown, Hispanic. So I don't want to make this into a race issue, but I do think the numbers bear out that is also happening.
I think that's one of those conversations that we have to dive deeper into next time here. I do want to ask you guys this final question, and obviously Ringstrom DeKrey criminal defense is where we want people to go. But when is the point, and Bruce, I'll ask you this, okay, look, I'm feeling uncomfortable. When's the point that I say I need to call you?
Well, if you're in jail, you need to call us. If a loved one has been arrested, you need to call us. If you have a strong reason to believe that you're under investigation, you need to contact an attorney. Weird little trick of the law. You don't have a right to remain silent if you are not under arrest or you're not detained. So that is an opportunity to retain counsel, because when you do that, your attorney takes away your right to talk, and law enforcement has to speak to your attorney. When in doubt, reach out to counsel.
So I think this is one of those things, right? And it's not anything like buying a new car, buying a new house, where all of a sudden You call and you're hooked in. Like you got your real estate agent. I mean, if I call you, Dane, saying like I'm feeling a little uneasy, then it turns out that I was just paranoid. I mean, what's that initial contact look like? I guess is a question I have for either you or Bruce.
Well, we don't charge for initial contact, and I think most good criminal defense attorneys don't, because people are in the midst of a crisis. You know, it's kind of a public service to give them that upfront information. I would want someone to do that if I were in custody.
Very good. Dane?
And we are immediate with it. We answer on the weekends. We answer at night. This is the type of job and the type of world where when you are in that crisis, you can't wait till tomorrow. And so we answer right away. There's no talk about money. Even if we never hear from you again, you're going to get our best advice in the moment, no matter what.
I've got 10 seconds. How do they get a hold of you then?
218-284-0484. 218-284-0484.
Fellas, we're going to do this again next month. It's been fun. It's been very informative. Got a lot of questions coming in. And actually, I think just a lot of great topics that we'll unpack next March, the first Wednesday in March already. But, folks, this is it for Law Talk today. Ringstrom, DeKrey is where you're going to want to go check them out. And when we come back on After News Live, Giving Hearts Day. Until then, you take care of yourself.